Hey there, Jim here from RJP Estate Planning. Okay, quick question. Do you know what'll happen to your estate when you pass on? You know, when you meet your maker, cash in your chips, so to speak? Well, no matter what you call it, the truth is that most of us don't like to think about death, especially our own. But if you're like George here and you have assets you'd like to pass on to your beneficiaries, well, you need to ensure that your affairs are in order before you, well, you know. Otherwise your estate enters into a long, drawn-out legal process called probate, where the state determines your assets, liabilities, and rightful heirs. And probate is an arduous process that, fortunately, we can help you avoid altogether. How, you ask? Well, to answer that, we need to understand why it happens in the first place. So let's take a closer look at George's situation. George and his wife Shirley own all of their assets together, and everything is titled in both of their names. When George dies, Shirley receives a death certificate from the state, which verifies that George has indeed passed away. Shirley then takes that death certificate to every one of their financial institutions. When the death certificate is accepted and recorded, George's name is removed from every asset that they jointly owned. Because Shirley's still alive and listed as the sole owner of these assets, she's issued a new title or deed that's in her name alone. Fast forward to when Shirley passes away, her beneficiaries are given her death certificate, and they go to the same financial institution Shirley contacted when George passed on, and provide them with her death certificate. The assets will now be frozen and will remain in Shirley's estate until the beneficiaries receive court approval to receive them. So at this point, there's a lapse in ownership. You see, there's no living individual listed on the title of these assets. The challenge is that the financial institution has no idea who has the rightful claim to the asset. They won't spend the resources, nor will they accept the liability to validate a last will and testament. This freezing of the ownership is what causes assets to go through probate, which is a legal procedure the state uses to prove three things. First, they want to verify that you've actually passed away, which is proven by the death certificate. Second, they want to take an inventory of the financial assets and corresponding liabilities you own. And lastly, they need to determine the rightful heirs to your estate, and all of that can take months or even longer to sort out. But the good news is that probate can be avoided by setting up an estate plan through RJP. And the best way to do that is through a living trust. You see, even with a will, your property is subject to probate. But by placing your assets into a living trust instead, well, you can customize the distribution of your estate while still retaining full control of all of your assets. And instead of a lengthy probate costing up to 10% of the estate value, a beneficiary can have everything you intended them to have, leaving them free to liquidate and distribute assets based on your specific instructions. So while resting in peace, you can be rest assured that your beneficiaries are able to move on without the burden and expenses of a painful legal process. So contact us today for more information and to schedule a consultation. RJP Estate Planning. Live for today, plan for tomorrow.